Good morning, my lords and my ladies. And today we are going to discuss on an act which, according to me, is the act for the common man. Because although it came very late as in 86, but the legislatures have realized the benefits of the act and the services that it could provide to the common man. By common man, I mean every man, whether he's wealthy, who is in a position to approach a court, initiate a litigation, or is not in a position to do so, and to do away with the rigors of technicalities which more often than not litigants face in courts. Now, we all know that this act has gone in tremendous amendment and a change in the year 2019. From 1986 to 2019, the changes that have been brought about in this act is purely based on the experience the various district forums, the national forums have faced regarding the shortcoming of the act. And that's the reason the scope of the act has been enlarged so as to do away with those technicalities. Now, when I draw your attention to the parliamentary debate and the speech, you will find that all these amendments have some, on the base of it, they have some logic because the district forums, the national forums have faced difficulty in enforcing provisions of the act in certain circumstances. And the wrongdoers could go away scot-free because the act did not provide for protection. And that's the reason you will find that prior to the 2019 Act coming into force, courts have gone to the extent of trying to expand the application of the Act by interpreting the provisions and the definitions in such a manner so that they can cover and actually act as a panacea to the problems that the problem is facing. The 1986 Act, which has now gone a change, was initially an act which would cover which had a very limited scope of application so far as consumers are concerned. Although there has not been much change, but there are certain quarters where the act could not reach. And my endeavor today would be to initially just see as to what are the changes that have been made and how the scope of the act has been enlarged. If to do that, if I may just ask, sir, if you could just project the 1986 Act on the screen. It's there. Now, I'm sure all of you have had the occasion to notice the changes, but I would try and draw your attention to some of the changes which according to me are very, very relevant, and they really do enhance the scope and bring in people who initially were not within the purview of that. If we could just concentrate on some of the amendments that has been brought in, that would be enlightening us as to the enlargement of the scope of that. If you come to the definition clause, the first amendment which has been introduced is advertisement. In the old act, which is on the screen, you will not find that advertisement was there in the previous act. The reason why advertisement has been introduced is because of the advent of e-commerce that has come. Now, initially, if I am a consumer and I go to a particular shop or a particular place to buy a product, it's me who is volunteering to go, and I am entering into a contract with the dealer of a particular manufacturer, and the choice is mine whether to buy an LG product or a Samsung product or a Sony product. The choice is mine. Initially the choice was mine, and this choice a consumer is to make depending on what warranties, guarantees the company was providing. So the dealer had no representations to make. It was the manufacturer who was giving these warranties and guarantees and trying to advertise its products by saying that, look, this is what I am selling to you, and coupled with whether there is a warranty or a guarantee. Now, in the event the product doesn't function, any product that doesn't function in the manner that I thought was beneficial for which I purchased the product, I had to go and complain either before the court and initiate my right either under tort or under the Sale of Goods Act. Now, under both these two legislations, either in tort or under the Sale of Goods Act, the seller always had a defense, and the defense was that I had made these representations, and beyond this, I had not said anything. Therefore, you, the buyer, you prove that you were actually misled. So the burden was on the consumer to show that he was misled. Now when this system started developing, the manufacturers took help of another third person who was an advertiser. Now the advertising agency is a person who is not connected either with the product or anything to do with the product, but he is being appointed for the purpose of reaching the consumer to the extent possible, if necessary inside their homes through televisions, internet, whatever may be the forum, and to lure him to purchase the product of which he is advertising. Now, in the process of luring, they make very many promises. Now, these promises which they make, they don't know whether the correctness of the promises are true or not. They are being told to advertise, they do it. Now, this act now is trying to rope in the advertiser also. And if you look at the definition right now, advertisement means any audio or visual publicity representation. This representation is made by the manufacturer through the advertiser. Endorsement or pronouncement. Endorsement is something which is another chapter. Endorsement means the involvement of a celebrity most of the times, who due to his public figure and being a celebrity, people have a tendency to have confidence in him, like cricketers, footballers, things. So depending on the fan following which he has and the TRP which he possesses, people have a tendency to believe or get attracted to what these men say. And courts have now gone to the extent of even saying that the endorser may also be held responsible if he is not sure of what he is leading to the public at large. So endorsers have been brought in, representation Batman, pronouncement by means of light, sound, smoke, gas, print, electronic media, internet, website, and includes any notice, circular, label, wrapper, invoice, or any such thing or other document. Now, if you look at the definition of advertisement, it is very clear that any form of representation, any form, in writing, which is a promise made, it's not an offer, it's a promise made, that if you buy this, you get this. You are now within the four corners of the Consumer Protection Act 2019, which was not there under the 1986 Act. So in that way, this scope of the Act has been immensely enlarged. But merely enhancing the scope of the Act by including advertisement did not suffice the purpose. So certain further amendments were required to rope in those persons. For that, if you kindly look at the definition of complainant, you will find there is a very interesting change that has been made. I am not going into the other amendments like introduction of Central Commission Authority, because those are administrative, those may not be of much relevance. Now, complainant, you will find that three more groups of persons have been included in this. Under the old Act, there were four complainants. There was a consumer, a voluntary consumer association, the central government, state government, or the central authority under the old Act. Under the new Act, you will find there is a concept of mergers of one or more consumers, where there are numerous consumers having the same interest. So, by this, they have allowed what in civil procedure code we call joinder of causes of action. They have allowed one or more consumers to come in. Suppose, for example, this is what happens. Suppose I buy a product today. The warranty of the product, say I buy an air conditioner from any company, I don't want to name a company, and the warranty of the compressor is 7 years. Now after 4 years the company becomes insolvent. Could be. After 4 years the company may come and say, which more often happens nowadays, that we have upgraded our machinery and therefore the machine which you have possessed, we don't manufacture these parts anymore and therefore we are unable to give services. Now, this can happen to one person, as this can happen to very many persons. Now, suppose a group of people, suppose a cooperative society, it announces that all our members can purchase an air conditioner of this make, and 10 of those people purchase it. Then all the members of the cooperative society can collectively lodge a complaint, which was not there under the old Act. So it brings in one or more consumers where there are numerous consumers having the same interest. This is also very important. In case of death of a consumer, his legal heir or legal representative is also a complainant. Now this is something which you will find has actually gone on to the extent of nullifying the well-known principle that a personal cause of action dies with the person. Previously under tort or under any other law where you are espousing a personal cause of action, it dies with the person. The only way it survived under the common law is that during the lifetime of the person, if he had an adjudication done and his right was recognized by a court, then and only then that right gets transferred to the legal heir. But if I am personally injured, then it's my cause of action which will die with me. One of the biggest examples is defamation. Defamation dies with the person. But here they have introduced it in a manner that if a consumer dies, then the legal heirs can pursue. Now, this right of a legal heir to pursue the claim is that of the consumer who had that right. So therefore, if the cause of action survives, the cause of action to sue survives, then under the previous Act, this right was not there. Under the new Act it is. Now this case, this introducing of this cause of action has arisen because there are line of cases prior under the 86 Act where an argument was to be made that under an insurance claim, if a person dies, then the question arises as to how far the legal heirs can pursue the claim for recovery. There is a contract. The rights and liabilities would be governed under the contract of insurance. But more often than not, the most common defense the insurance companies take is suppression. That the insured had actually suppressed and therefore the insurance policy or the contract has become void. That defense they used to take under section 45 of the Insurance Act. Under that they are liable to challenge the actions of the insurer, the insured. That has been done away by this amendment. And a minor's rights in case of a consumer being a minor, his parent or legal guardian has also. So the scope of the complainant has gone way beyond what it was there under the old Act. There has also been a significant change in the definition of a complaint. If you see the old definition of complaint under the 1986 Act, it was only restricted to an unfair contract or unfair trade practice or a restrictive trade practice. Goods brought by him or agreed to be brought by him suffer from one or more defects. Services hired or availed or agreed to be hired or availed by him suffer from deficiency. Now thereafter there has been a host of introductions into the new Act. If you look at it, a trader or a service provider, as the case may be, has charged for the goods or for the services mentioned in the complaint. Do you have a copy of the new Act? Otherwise, can you share the screen with the old Act and the new Act? You are sharing the new Act now. So, a trader or a service provider, as the case may be, has charged for the goods or for the services mentioned in the complaint a price in excess of the price fixed by or under the time being in force or displayed on the goods or packages containing such goods, or displayed on the price list exhibited by him by or under any law for the time being in force and agreed between the parties. So far as A, B and C are concerned, they have roped in the provisions of Weights and Measures Act. So far as D is concerned, they have roped in a major portion of the Contract Act. So this entirely new concept which is under the new Act brings in to play some provisions of the Contract Act, some provisions of the Weights and Measures Act, and all the introduction or all the improvement that have been made. If you look at the bottom line is to make the consumer aware as to what he is buying, what is the price the manufacturer is offering, and at what price he can purchase it. The reason is this: if you have a fixed price in the market, then as a consumer you have a right to compare and find out which is the best price that suits your budget and which is the best product that you can get. So it's all about trying to put an obligation on the trader that it's your duty to disclose. It's not the consumer's duty to find out. So if you see the burden is now being slowly shifted from the consumer to the trader or the seller or the businessman, that if you are to do business in this economy, it is your obligation to keep the consumer informed. And informed in not such a way that it should be a clear, placid way of trying to find out what I am buying. There should not be any hidden corners, there should not be anything that the consumer has to go from pillar to post to find out what is it. Everything should be available to him. The idea is to make a well-informed consumer. This is the purpose of that. The other change is goods which are hazardous to life, tobacco, khaini and whatever, and safety when used are being offered for sale to the public in contravention of the standards relating to safety of such goods as required to be complied with by or under any law for the time being in force. There is an act called Hazardous Substances Act or something like that, which has an authority under it, where a complaint can be lodged. But more often than not, most of the states do not have the constitution of the authority for the purpose of approaching. But now it has been brought within the ambit of the consumer forum side, where the trader knows that the goods so offered are unsafe to public. So the burden now shifts to the trader, it's not for the consumer anymore. The services which are hazardous or likely to be hazardous to life, kindly see, not only hazardous, which are likely to be hazardous to life and safety of the public, when used, are being offered by a person who provides these services and he knows it to be injurious to life and safety. And a claim for the product liability action lies against the product manufacturer, product seller, or product service provider, as the case may be. So, if you look at the entire gamut of the complaint that I can lodge and against the persons with whom I can lodge, the scope extends to very many persons. So from the person who is manufacturing a product till the person from whom I am buying, all the persons in the chain now can be held liable for the purpose of lodging a complaint. It starts from the product manufacturer, the product seller, the product service provider.
I think if you speak, you'll be audible.
I think so.
Yeah.
I think so. So, what I was trying to impress upon you is that if you look at the trend of the way, manner in which the act is progressing, one thing becomes very obvious, to me at least, that it is obvious that you need industry and commerce for the purpose of development. But you can't take it to such an extent that nobody is accountable for your acts. So, initially, the 86 Act pinned down the accountability on limited number of persons. And if you see the way the scope is being enlarged, all it is trying to do is, on the one hand, trying to keep the consumer informed, and the other hand is trying to make a group of persons who are doing business and connecting to the consumer accountable for that. So accountability goes up. If accountability goes up, and this is the check and balance which the Act has brought in, so that you know that if you are infringing any of the consumer's rights, then it's not that you can take the consumer for a ride. You are accountable, and to have you brought before a forum, the law has become very easy. You don't have to check the consumer need not be a wealthy man, the consumer, because most of the times prior to this act came into force, it was one consumer fighting against a big institution or a big manufacturer. So most of the times they thought it was not worth it. But now that access to justice has become very easy, now a consumer can just lodge a complaint by filing up a form, and it's the duty of the commission to take up the complaint and pursue it. So that way, not only has the accountability of these persons increased, access to justice has become easy, and therefore now they have to be on their toes and make sure that they do not take the consumer for a ride. So that is my understanding of explanation of enlarging the scope of complaint. Now, this was already there, but only thing which is very important is in the definition of consumer. You will find that there is a change in section 2, subsection 7, Roman 2, the last line. The last line, but does not include a person. This is the only change that has been introduced, but does not include a person who avails of such services for any commercial purpose. So all it says is that the person who is buying a product for commercial purpose is not coming within the definition of a consumer. And there has been an introduction of an explanation in B, which defines what does it mean. The expression buys and goods, buys any goods and hires or avails any services includes offline or online transactions through electronic means or by teleshopping or direct selling or multi-level marketing. So there has been a slight change in the definition of a consumer so that the powers given to a consumer under the Act are not being misused by persons who use it for commercial purpose. Because access under this Act to the judicial system is really very quick and very easy. So there are chances that they may be misused by persons who actually do not come within the definition of a consumer. Now there is a whole lot of awareness which is reflected in introduction of a whole bunch of rights which is now called consumer rights. Under the old Act, you will not find that anything was defined as to what is the right of a consumer. Meaning thereby that whatever rights the consumer had under the common law was the right of a consumer. Now under the common law, in all the laws that you take which a person could avail, the Sale of Goods Act, the Weights and Measures Act, the proceedings under the law of torts, they all proceed on the basis of civil rights which say that he who alleges must prove. So in all these acts which were available prior to the consumer's rights being defined, the burden was always, as I started by saying, the burden was always on the plaintiff. And sometimes these burdens became so insurmountable because of lack of evidence, because of lack of documents, because of adversary holding on to documents which was not accessible to a consumer. In more cases than not, the plaintiffs could not succeed in getting the real amount of damages, and courts used to only award nominal damages and costs. Now, this entire burden has now shifted from the consumer to the defendant. Now, it's the defendant has to come and show that what the consumer is alleging is not correct. So that does three things. The consumer is just to show that the product is defective, that's it. If he comes within any of the definitions of the complaint, he is only to prove that this is what has happened. And the entire explanation, the entire accountability has now shifted to the manufacturer, the product seller, the product buyer, whoever it is, to come and justify that what the consumer is saying is not correct. So there has been a, the change of dice by introducing this. So the burden is now on the consumer. And the fact that the consumer is no more claiming a right under any common law, but is claiming a right under the Consumer's Act, this consumers' rights have now been defined and introduced under the 2019 Act. Now, if you very hurriedly go through the consumer rights of a consumer, you will find that it's all about product awareness, accountability, and compensation. The easiest way of getting it. Commercial right includes the right to be protected against the marketing of goods. What does it mean? Marketing of goods, products or services which are hazardous to life and property. Suppose I am a patient who suffers from high cholesterol. I go and buy a packet of chips. Previously, when we used to buy it from the vendor, we used to buy only chips without knowing what it is. And we consume it without knowing that actually I am doing harm to myself. But I am a consumer who has been offered this service or this product and I am buying it and using it. But now, by virtue of this act, you will find that every product gives you the exact contents of what is there, how much of it is harmful for you or likely to be harmful for human consumption, so that you are made aware. And even thereafter, if you buy and purchase it, so far as the manufacturer is concerned and the seller is concerned, it has discharged its obligations. Whether it's vegetarian, whether it has fat, if it is fat, how much of it is saturated fat, whether it's good for health, bad for health, everything is there. So, the minute you buy a product, or if you go to a shop to buy a product, you actually are being informed. If you want to know, you are actually being informed as to what you are buying. And thereafter, if you buy it knowing that this is what I am buying. So this is a right to be protected against marketing of goods, products and services which are hazardous to life, like the warnings we have on cigarettes, gutkhas, pan, bidis and other stuff. The right to be informed about the quality, quantity, potency, purity, standard and price of goods, products or services as the case may be, so as to protect the consumer against any unfair trade practice. The right to be assured, whenever possible, access to variety of goods, products or services at competitive prices. Now, here you will find that there is a slight deviation from the usual manner in which the rights have been described. The right to be assured wherever possible. Now, suppose today I go to a mall to buy a shampoo, and I don't have any particular shampoo in mind or any particular product in mind. I will be open to buy everything that is there on the shelf. Each of the products have their particulars there. But it is not possible for that man to put on sale everything that is available under the sun. So, out of 15 brands of shampoos, if they are available in India for argument's sake, if he is putting on the 5 brand shampoos in the store, and the consumer feels after purchasing a product that the stall owner did not inform me that this same product of another brand is available to me at a lesser price, and therefore I have been misled, that cannot be the consumer's complaint, because it is not his duty to inform you about what is there available in the market. His duty is to inform you that these are the 5 products I am selling, I am responsible for these 5 products. If you want to find out that whether there are other products of competitive prices, then the internet is at your service. Nowadays, whenever we go to the shop, at least what my wife does is, when she checks up a price of a product, the next thing she does is she goes to Amazon and finds out what's the price. And if it is at par or very nearly, then she buys it, otherwise she says, I'll go back home and I'll get it online. So that's the consumer awareness. So she knows, but previously when these online marketing systems were not there, we did not know what the dealer was taking. The manufacturer and the dealer, we always had a dealer's percentage, which is being done away. So that way it's not only become competitive, at the same time now we know that what we are purchasing, we are getting the best price or the best discounts that are available in the market. So rights to be heard, to be assured that the consumer's interests will receive due consideration at appropriate forum. This is a right which was always there, but now they have made it a statutory right. The right to seek redressal against unfair trade practice or restrictive trade practice or unscrupulous exploitation of consumers, and the right to consumer awareness. Now, this bundle of rights, which have now been defined under the Consumer Protection Act, is only for the purpose of assisting a consumer to give before a forum and say that my right is being violated, not under A Act, B Act or C Act, but under the Consumer Protection Act. Because today, if I am a seller or a purchaser under a Sale of Goods Act, then all the limitations, all the technicalities of the Sale of Goods Act will apply to me. If I am a seller under the Sale of Goods Act, or a buyer or a purchaser under the Sale of Goods Act. But if I am a purchaser or seller under the Consumers Protection Act, which is my consumer's right, then all those technicalities and all those burden, evidence, they may not strictly apply here. So the reason is that if I am a consumer, I will have easy access to justice and it would be a speedy, fair trial without me getting entangled into legal technicalities. I don't have to hire a lawyer. If I am to go to a civil court today and file a case under the Sale of Goods Act, I have to hire a lawyer because he knows. But here, if I am a consumer and my right is covered here, I just go and lodge a complaint. So this is easy access to justice. So this bundle of rights which have been introduced, I think they actually has helped the consumer to walk straight into a consumer forum without even consulting anybody. Now there are minor changes in the definition of defect, but that is not very much of important. The two very important changes that have been introduced in the definition of deficiency, you will find initially deficiency included a closed section. It was not an open-ended definition. So to make it an open-ended definition, they have introduced two facets of it. One is any act or negligence, just after 11A, if you could see on the screen. Is it 11 on the screen? Any act of negligence or omission or commission by such person who causes loss or injury to the consumer. Now, negligence was always there under that previous act also. An act of negligence, omission or commission by the person who causes loss or injury to the consumer is, again, if I may say so, the attempt to shift the burden from the consumer to the product seller or manufacturer or the defendant. The reason why I say so, prior to this act coming into force, under the 86 Act, if anybody wanted to sue somebody for negligence, omission or commission, the only action that was available to him was the civil action in tort. Now, an action in tort has a lot of defenses, starting from contributory negligence, res ipsa loquitur, all those English principles they apply. And in those cases of tort, it was the burden on the plaintiff to prove that the defendant was negligent. And because of his negligence, I have suffered damages, and that damages had to be quantified also. So this entire thing was on the side of the plaintiff. Now if you look at the definition and read it with the consumer rights, all I need to show is there has been deficiency in service. And nothing more than that. Now there has been certain new introductions in the 1996 Act, and the major one is 212 and 16. This portion is there because of the advent of e-commerce. You will not find the definition of design or the definition of e-commerce under the old Act. So this is something which has been brought in by this new Act, and I'll try and first read it and thereafter let us discuss and see how far it has gone on to rope in those persons who carry on business through the e-commerce platform. Design in relation to a product means the intended or known physical and material characteristic of such product. Is it on the screen? Design in relation to a product means the intended or known physical and material characteristics of such product and includes any intended or known formulation or content of such product and the usual result of the intended manufacturing or other process used to produce such product. All of you are aware that this word design finds place in Trademarks Act also, in Patents Act also. But that design and this design are totally different. This design, in the manner the word design has been used under the Consumer Protection Act, is in relation to a product which is designed to inform you about its physical and material characteristics, which will include formulation of the contents of the product, like anything you pick up. Even if you pick up that sanitizer, you will, at the back of it you will find what it contains, how much of it is there, what percentage is there, and those instructions are there. And the usual result of the intended manufacture of the process used for such product, how it has been manufactured, by what process. Then there has been introduction of direct selling. Director General and District, these are administrative, I am not going into it. Then e-commerce, very important, because this is absolutely new concept. E-commerce means buying or selling of goods or services, including digital products over digital or electronic network. This is what we buy online, basically. Now, what is important is, if I buy a product online, I don't have direct access, I don't know who the manufacturer is unless I want to find, number one. Number two is, I don't know if a product is defective, whom to hold responsible. So, if all of us buy products online, you will find that after that product is advertised, there are certain product related queries given. Now these product related queries are provided as a part of accountability of the seller. So it's making the consumer. And apart from that, you will also find customer reviews. which customer reviews cannot be curtailed or managed by the product seller. These customer reviews are being managed and and put on the website by the platform through whom the product manufacturer is being sold. So if I am a product manufacturer and I want to sell my goods online, I'll have to approach a platform, which platform I will be using for the purpose of advertising the products. So there is an underlying contract between me and the person with whom I am entering into the contract for the purpose of advertising my product. If you get any opportunity, any of you get an opportunity to see those contracts between the product manufacturer and the platform, you will find there is a host of disclaimers over there. Those host of disclaimers are just to protect the interest of the service provider or the owner of the platform. That I am selling your goods, but I am not taking any of these responsibilities. But mind you, these disclaimers are between the product manufacturer and the platform owner. It does not percolate down to the consumer. So far as the consumer is concerned, the consumer's rights are intact. They cannot be touched by any agreement either between the product holder and the product seller and the platform owner. Say Amazon and say Tata. Tata wants to sell its, say anything on Amazon platform. It's one of the products available. If you see the agreement between Tata and Amazon, you will find that there is a host of disclaimers that Amazon has taken from Tata. That I will not be responsible for this things. But if the product is defective, I as a consumer can initiate proceedings against all of them. That is the right which the Consumer Protection Act is giving. I will start not only from the person who has delivered the goods to my house, I can sue him also, I can sue the person who is bringing it to my house, I can sue the platform owner, I can sue the manufacturer and all those persons from whom I have received services. Now who will indemnify whom is not the concern of the consumer anymore. Amazon may say I am facing a claim for damages, you Tata indemnify me. The service provider who is bringing the transporter may say, I am facing a claim, you the product seller indemnify me. Those are interesting contracts which doesn't get any way affected by the rights of the consumer. So that is where the introduction of consumer rights and introduction of bringing in these people within the domain of the Consumer Protection Act actually helps the consumer to get its redressal from only one forum.
So here I'd like to put a question. For example, if the product is defective and the consumer has filed a case against both the manufacturer and the retailer. Now, once the forum decides that it is found to be a defective product and there was deficiency in service as well, so the compensation is payable by both the equal parts, or how do we?
Yes. The consumer, is the thing is,
how do we allocate the amount of
no,
compensation?
thing is, madam, if you are taking the definition, you are taking a whole group of persons as service provider. It is, you are not. So that is where I was trying to come at. This suppose the example which you gave. If I go to a civil court and I complain and I succeed in proving that the product is defective, the next question comes is compensation. The product manufacturer will say, I manufactured a perfectly good product, but it got damaged in the way because the transporter was available. Now the transporter will say that when I delivered the goods to the retailer's godown, he didn't say anything about any defective goods, nor did he return the goods. So therefore it is presumed that he has accepted the correct goods and therefore the damage has taken place as his case. Now, with these three fact scenarios, with three defenses, I as a plaintiff, what do I do In a civil court, then I will have to go on proving and disproving each of the defenses wrong. If I am in a civil court. If I am in a consumer court, then it is for them to say if there is a deficiency in service. I am not concerned with at whose instance the deficiency has taken place. I am to be compensated. So if I have sued all of them in a line, the decree can be jointly and severally against all of them. Now, thereafter, who will indemnify whom? Thereafter, suppose the retailer may, after suffering a decree, may go and file a suit against the manufacturer saying that because of you are. So, the consumer is not involved here. So, the consumer's rights are on one side, which are superior vis-a-vis all these persons. So, that is the change which the Act is trying to bring.
So it's not necessary for the Commission to allocate the exact.
Not at all.
We
Not
just
at all.
general decree
Not
saying
at all.
that's
Not at
a
all.
problem, no?
Rights inter se defendants are not the, because the Commission is only protecting the consumer's rights. Anything beyond that is the domain of the civil. Because all of these persons, the manufacturer, the service provider, the transporter, whoever, they are all they are doing commercial. They don't come within the definition of consumer. Each of them are commercially interested in this entire chain of events.
But here there's a possibility that the consumer may not get the relief immediately, because then the manufacturer and the retailers go to the civil court. Isn't it?
They can go to the civil court,
Because
but
the minute they pay, then they have accepted their respective damages, amount of damages.
if they pay off the consumer, then the consumer, the jurisdiction of the district forum comes to an end, or the national forum comes to an
But
end.
if they go to a civil court, then.
If they go to a civil court, that does not prevent the consumer, because since it's a quasi-judicial act and the civil court does not have the jurisdiction to interfere with and stall any proceedings before any consumer forum.
My point was that what if they do not pay as per the decree?
If they don't pay, then there is a provision of penalty which has been introduced under this act also. They are enforceable rights. I come to that how is it executable? Because there are two more provisions that have been introduced. One is mediation
Yes.
and another is penal provisions. Now, mediation is because if it's a manufacturer and he doesn't want his image to be tarnished in the public, or if he owns up that yes, that was a defect on my part, or if he feels, most often than not nowadays I find that consumers fear, the traders feel that it's easy to mediate and make the consumer go with whatever the compensation, because if this goes on, then if it goes for the trial, then I might have to land up paying more compensation. So nowadays, because of this, so much of power being given to the district forum and to the consumer, now they are now falling into the purpose for which this act is there, accountability. Now they are owning up to their own accountability. Otherwise, they would have left the consumer at large. So it has. The only other day I was reading a judgment when a person had complained against Tata Motors, saying that I had purchased a car on the premise that it was advertising that it was giving 25 kilometers per litre, and on the basis of that promise I purchased this car, and it now transpires that I am only getting 18 kilometers per litre. So there is a false promise made on the basis of which my rights have been termed. And the West Bengal Consumer Forum has awarded damages to the consumer. Now this is something very common. We are like, prior to the consumer's rights which we had, each of us know that the advertisements which they say, each of us know may not be 100% correct. But as consumers, we have no options but to buy it. Suppose today I want to buy a car which promises a particular mileage, and below that there is in very small words it's written in ideal testing conditions. We don't notice that. What does it mean is that's the disclaimer. That if you are driving this car in a city, then you will not get what I am promising. So ideal test condition means that if you are driving this car on a runway, now nobody drives a car on the runway. So therefore that is the disclaimer which he has kept to himself. But even then, if you are advertising that your car is giving 25 kilometers per liter, the West Bengal State Commission has awarded damages against Tata for making, and that included the advertising agency also. It's just because when I was going through this estate trial, and they were also made liable for making a false representation to the public at large.
Please have the citation.
Yes. The citation you'd like to share. Can I give it during the break? Yes. Now, goods have been defined. Harm has been introduced. Now, there is one interesting line in this definition of harm. Harm in relation to a product liability includes, so it's an inclusive, it's an open-ended definition. It can bring in more than what is there. Damage to any property other than the product itself. Personal injury, illness or death, mental agony or emotional distress attendant to personal injury or illness or damage to property, or any loss of consortium or services or other loss resulting from harm referred to in clause I or subclause II or clause III, but shall not include any harm caused to a product itself or any damage to the property on account of breach of warranty, conditions or any commercial or economic loss, including any direct, incidental or consequential loss relating thereto. This has been introduced only for the purpose of e-commerce and the rules that are there. Misleading advertisement is an entirely new concept which is there now. Which includes false description of product, false guarantee, misleading consumers as to the nature, substance, quality of the product or services, conveys and expresses an implied representation. Kindly mark, it's not express, it can be implied also, which, if made by the manufacturer or seller or service provider thereof, would constitute an unfair trade practice. Now, there are many instances of implied representation. You all have come across cases where two big manufacturing houses compete each other on defamation for advertising their products. It's very rampant. This happens all over the country. One product manufacturer says mine is the best. The other product manufacturer says that mine is the best, even best than the one who says the best. So these are ways, indirect ways, which the manufacturers fight amongst themselves for the purpose of getting advantage in the advertising world. Now there is a very well-known fight which goes on an international platform between Mercedes and Audi. It's all over the net. If BMW and Audi come out with an advertisement, the very next day or within a week, Mercedes will come up with an advertisement saying that we are a superior class. But they do it in a very, very indirect way. You need to understand everything to try and understand where it is getting at. That's indirect way of it. Now, in this indirect fight between the manufacturers, if a consumer gets roped in, suppose I am very impressed with the advertisement which Mercedes has taken out to show me that our product is superior than that of BMW or Audi. And I fall for that implied misrepresentation. It didn't say that directly that our product is superior. It indirectly indicated and hinted to me that our product is far superior than these two other car manufacturers, and I fall for it. That's an implied misrepresentation, and therefore in the event I find out that the representations made were actually not correct, or I am not happy with the product, then I can hold these persons responsible under the definition that it has caused harm. So previously these things were always there, they were all within the ambit of civil law. But to bring it within the consumer forum and give these powers to the district judge, I feel, and I was discussing with him yesterday only, that I feel that this act, if put into proper perspective and followed to the T, will be not only be the act which the country has today, but it will take away a huge burden from the civil code also. Because the entirety of unknown tort law, the Sale of Goods Act, any transaction that we do every day, anything we buy, anything we purchase, anything we do, any services we level, every advertisement we see every day, they are now all brought within the ambit of this act. So, I feel this would be a revolutionary, this amendment has been a revolutionary amendment, and if put into proper service, it can achieve more than what a civil court can achieve. The powers are more, and it actually brings in concepts of all the civil acts under this new amendment. How much money is allotted for this? Oh, RERA is there. So I need to quickly wind up on this. You see, there is a folder there where you will find the comparison of the two acts. Can you just share the folder on the screen? No, I'll tell you this. If I open it from here, you can Oriental research paper as like this. Now this gentleman, before coming to this, I'll be very candid, since consumer, I don't have very many opportunities to go to consumers forum. I did not know much about this 2019 amendment, but when I started researching on it, I found that this act or this forum is much more powerful than a civil forum. Now, while doing so, I have come across this research paper. If anybody is interested in perusing it or having a link of it, my friend here can share it with you. It's there in the folder. Sorry? Oh, it is not downloaded. You can download right now. Or you can, because this actually is very helpful for anybody who wants to. This has been downloaded by my juniors. I don't know. If you see, instead of wasting your time on comparing this is a research paper which has come out from Professor Sindhu. I was actually going through this. If you scroll down, you will find that he has made a comparative narration of what the 2019 Act has brought about and what are the changes that has been introduced. And in the event you want, you can have a link shared through my friend, because I was allotted 1 hour time for all the 3 topics. I have only been able to cover only one. The other topic which is of some relevance today, and if I may use the word a hot topic, is the application of RERA vis-a-vis the Consumer Forum, which is C. So far as RERA is concerned, as well as this Consumer Protection Act is concerned, both are special statutes. That is where the dispute arises. Not only these are special statutes, they are substantive law which has an inbuilt procedure of adjudication in them, and at the same time it provides for remedies for the purpose for which these respective acts have been brought in by way of legislation. Now, the Consumer Protection Act 2019 is in its ambit much more larger than that of RERA, because RERA only takes into account a particular group of persons which they are called promoters or builders, who are providing services to the mankind by providing them shelter, house, by bringing projects. It's the housing industry which we call in one short term. Now, services under the Consumer Protection Act would also include services provided by these promoters and developers and builders under the RERA Act. Now, the question that has arisen and had fallen for discussion is, suppose there is a dispute which can be adjudicated both by the authorities under the RERA as well as the Consumer Forum. Where should the consumer go? If he is a consumer under the Consumer Protection Act, he can avail the services that there is deficiency in services under the Consumer Protection Act. But problem arose that so far as RERA is concerned, if it comes within the jurisdiction of RERA, then that act says that that has exclusive jurisdiction over all issues which are governed by that act and no other. The civil law, so civil court jurisdiction is out of question. Forum was not there. A quasi-judicial forum was not in that exclusion clause. Coupled with that, there's a section 3 in that act which says that it would be read in consonance with other acts and not in derogation of other laws. Because there have been cases where proceedings under the Consumer Protection Act were being proceeded, were actually pending when this RERA Act had come. And the RERA Act, on being introduced, objections were taken before the forum that these disputes are actually covered by another act, and therefore the Consumer Forum does not have the jurisdiction to decide with such problems. Now, this has travelled way up to the Supreme Court. And the Supreme Court has in no uncertain terms have said that both of these are concurrent remedies. This is available, this remedy to a consumer or a person who is aggrieved by the actions of a builder. He can either approach the Consumer Forum, he can either go to RERA, he has an option to elect. If he has an option to elect, he can elect any one of them. So there is no hard and fast rule that a consumer protection dispute pending before the consumer forum will lose its jurisdiction just because the RERA Act has been introduced. Now, instead of me trying to, can I have my tab back, please? We were on the issue as to whether by the advent of the RERA Act, whether the Consumer Protection Act has taken a backseat, or whether both of these can be pursued together. Now, instead of trying to discuss this thing on the issue, because this issue has now been squarely settled by the Apex Code, and if you can come to straight to page 807, paragraph 22. Yes. You see, the issue here was, paragraph 22 has set out the issue by the Supreme Court. The question whether the remedy is available to a consumer under the provisions of the Consumer Protection Act would be additional remedies was considered by the court in some of the notable cases. All these are Supreme Court cases, like the one at paragraph 22.1, it says, from the statement of objects and reasons and the scheme of the 86 Act, it is apparent that the main objective of the Act is to provide for better protection of the interest of the consumer, and for that purpose to provide for better redressal mechanism through which cheaper, easier, expeditious and effective redressal is made available to the consumers. To serve the purpose of the Act, various quasi-judicial forums are set up in the district, state and national levels with wide range of powers vested in them. These quasi-judicial forums, observing the principles of natural justice, are empowered to give relief of a specific nature and to award, whenever appropriate, compensation to the consumers and to impose penalties for non-compliance of their orders. As per section 3 of the Act, as already stated above, the provisions of the Act shall be in addition to and not in derogation of any other provisions of any other law for the time being in force. Having due regard to the scheme of the Act and the purpose sought to be achieved to protect the interest of the consumers better, the provisions are to be interpreted broadly, positively and purposefully in the context of the present case to give the meaning to additional extended jurisdiction, particularly when section 3 seeks to provide remedy under the Act in addition to other remedies provided under the Act, unless there is a clear bar. Now, this section 3, I might point out, this was discussing the 86 Act. So section 3 in the 86 Act is probably section 100 in the new Act. The provisions are the same. Then National Seeds Corporation is very well celebrated judgment, which has been taken into note of. It can thus be said, paragraph 22.2, it can thus be said that in the context of farmers, growers and other consumers of seeds, the Seeds Act is a special legislation. I'll tell you what had happened in this Act. There is a concept of Seeds Act, where the farmers, there is an authority which distributes seeds to the farmers. Now what had happened is that the manufacturer or the seller of the seeds is liable to be punished for the purpose of selling seeds which are of substandard quality. And for that a complaint could be lodged before the seeds authority against the manufacturer. Now, some of the farmers had gone and lodged a complaint before the Seeds Act authority, saying that because of substandard seeds we have suffered damages. But the Seeds Act did not provide any provision for giving compensation. So thereafter they availed the remedy under the Consumer Protection Act. And there it was held that in spite of the Seeds Act being there, the Consumer Protection Act being an alternative forum, which provides for compensation which the Seeds Act does not provide. Therefore, under the Consumer Protection Act, compensation can be given and was awarded. If I may just now read this paragraphs 57 and 62, it can thus be said in the context of farmers, growers and other consumers of seeds, the Seeds Act is a special legislation insofar as provisions contained therein ensure that those engaged in agriculture and horticulture get quality seeds, and any person who violates the provisions of the Act and the rules is brought before the law and punished. However, there is no provision in that Act and the rules framed thereunder for compensating the farmers, etc., who may suffer adversely due to the loss of crop or deficient yield on the account of defective seeds supplied by a person authorized to sell the seeds. That apart, there is nothing in the Seeds Act and rules which may give an indication that the provisions of the Consumers Protection Act are not available to farmers who are otherwise covered by the wide definition of consumer under the 21D of the Consumer Protection Act. As a matter of fact, any attempt to exclude farmers from the ambit of the Consumer Protection Act by implication will make the Act vulnerable to an attack of unconstitutionality on the ground of discrimination, and there is no reason why the provisions of the Consumer Protection Act should be so interpreted. Since the farmers, growers purchase seeds by paying a price to the appellant, they would certainly fall under the ambit of 21DI of the Consumer Protection Act, and there is no reason to deny them the remedies which are available to other consumers of goods and services. All that I am trying to say is that if there are two special legislations governing a particular fact, that does not mean, and both the legislations say that they have to be read in conjunction with other laws and not in derogation thereof. That means that the legislation's intention was that both the forums had jurisdiction. Now, if we go a little further, in so-and-so versus so-and-so, the Supreme Court observed the other question which needs to be considered is whether district forum should not have entertained the complaints filed by the appellants and directed them to avail the statutory remedies available under the Cooperative Societies Act. This is another act. Sri Neeraj Jain vehemently argued the forums constituted at the Act cannot grant relief to the appellants because the action taken by the respondent number 1 was approved by authorities constituted under the Societies Act who were not implicated as parties in the complaint. In our view, there is no merit in the submission of the learned senior counsel. In the complaints filed by the appellants had primarily challenged the action of the respondent number 1 to refund amounts deposited by them and thereby extinguish their entitlement to get the flats. Therefore, the mere fact that the action taken by the respondent number 1 was approved by the Assistant Registrar Cooperative Society and higher authorities cannot deprive the appellant of their legitimate right to seek remedy under the Act, which is an additional to the other remedies available to them under the Cooperative Society law. Law in this issue must be treated as settled by the judgments of the court. The last mentioned judgment, then all these judgments are quoted on this point, and all these judgments of the Supreme Court have held that the remedy available under the Act, that is the Consumer Protection Act, is additional to the remedies available under any other statutes, and the availability of alternative remedies is no bar to the entertaining of a complaint filed under the Act. So, to address this issue, if I may now go to the question of RERA. Paragraph 24. If I may read from paragraph 23, sorry. Paragraph 23. 21, yes. It's highlighted, it's highlighted. Yes, go down, go down, go down, go down. Yes. Yes. It has been consistently been held by this court that the remedies available under the provisions of the Consumer Protection Act are additional remedies over and above the other remedies, including those made available under any special statutes, and that the availability of an alternate remedy is no bar in entertaining a complaint under the Consumer Protection Act. Before we consider whether the provisions of RERA Act has been any change in the legal position stated in the preceding paragraphs, we may note that the allotee placed in the circumstances similar to that of the complaints could have initiated the following proceedings under the RERA Act had come into force. If it is satisfied, this is important, if he has satisfied the requirement of being a consumer under the Consumer Protection Act, he could have initiated proceedings under the Consumer Protection Act in addition to normal civil remedies. So this is before the RERA had come into force. B, the other option available to him is, however, if he did not fulfill the requirements of being a consumer, he would initiate and avail only normal civil remedies. C, if the agreement with the developer or builder provided for arbitration in cases covered by B, mean if he does not fulfill the requirement of a consumer, he would initiate or could be called upon to invoke the remedies in arbitration. In cases covered under A, herein above, in accordance with the law laid down in MR versus so, he could still choose to proceed under the Consumer Protection Act. Meaning thereby that this remedy which is available to a consumer under the Consumer Protection Act is an addition to remedies available in a civil court, in addition to the remedies available under the RERA, is also an addition to remedies available under the Arbitration Act also. Thereafter, the exception that the Supreme Court has found in section 18 in paragraph 25 is where the Consumer Protection Act comes in. In terms of section 18 of the RERA Act, if the promoter fails to complete or is unable to keep possession of an apartment duly completed by the date specified in the agreement, the promoter would be liable on demand to return the amount received by him in respect of such apartment if the allotee wishes to withdraw the project. Then, such right of an allotee is specifically made without prejudice to any other remedy available to him. The right so given to the allotee is unqualified, and if availed, the money deposited by the allotee has to be refunded with interest at such rate as may be prescribed. The proviso to section 18(1) contemplates a situation where the allotee does not intend to withdraw from the project. In that case, he is entitled to and must be paid interest for every month of delay till handing over a possession. It is up to the allotee to proceed either under 18(1) or under the proviso of 18(1). The case of so-and-so, the RERA Act has definitely remedy to an allotee who wishes to withdraw from the project or return a claim for his investment. It is therefore required to be considered whether the remedy so provided under the RERA Act to an allotee is only an exclusive modality to raise a grievance, and whether the provisions of the RERA Act bar consideration of grievance of an allotee by any other forum. Section 79 of the RERA Act bars jurisdiction of civil court to entertain any suit or proceeding in respect of any matter which the authority or the adjudicating officer or the appellate tribunal is empowered under the RERA Act to determine. But this is only in respect of civil courts. Section 88 specifies that the provisions of the RERA Act would be in addition to and not in derogation of the provisions of any other law, which in terms of Section 89, the provisions of the RERA Act shall have effect, notwithstanding anything inconsistent contained in any other law for the time being in force. On a plain reading of Section 79 of the RERA Act, an allotee described in Clause B above, that is in paragraph 24, would stand barred from invoking the jurisdiction of the civil court. However, as regards the allottees who can be called consumers within the meaning of the Consumer Protection Act, two questions could arise. A, whether the bar specified under Section 79 of the RERA Act would apply to proceedings initiated under the provisions of the Consumer Protection Act, and whether there is anything inconsistent in the provisions of the CP Act with that of the RERA. Then paragraph 30, on the strength of the law so declared, Section 79 of the RERA Act does not in any way bar the commission or forum under the provisions of the CP Act to entertain any complaint. Provision 271(1) of the RERA Act entitles a complainant who had initiated proceedings under the Consumer Protection Act before the RERA Act came into force to withdraw the proceedings under the CP Act with the permission of the forum or commission and file an appropriate application before the adjudicating authority under the RERA Act, if he chooses the option. The proviso thus gives the right or option to the complainant concerned, but does not statutorily force him to withdraw such complaint, nor do the provisions of the RERA Act create any mechanism for transfer of such pending proceedings to the authorities under the RERA Act, as it is the mandate in Section 12 subsection 4 of the Consumer Protection Act. To the contrary, is quite significant. So, in no uncertain terms, now this is what I was drawing your attention at. Kindly come to paragraph 38. I am skipping it because it will take a lot of time. This is important because of the change. Lastly, it may be noted that the Consumer Protection Act 2019 has enacted by the Parliament to provide for protection of interest of consumers and for the said purpose to establish authorities for timely and effective administration and settlement of consumer disputes and for matters connected therewith or incidental thereto. Then the sections are quoted. Section 100 of the new Act reads like this. The provision of this Act shall be in addition to and not in derogation of the provisions of any other law for the time being in force. So Section 3 under the old Act has now been reintroduced as Section 100. Section 100, then paragraph 39. Section 100 of the 2019 Act is akin to Section 3 of the Consumer Protection Act, and Section 107 saves all actions taken or purported to have been taken under the CP Act. It is significant that Section 100 is enacted with an intent to secure the remedies under the 2019 Act dealing with the protection of interest of consumers even after the RERA Act was brought into force. So therefore, my lords and my ladies, so far as this 3 is concerned, all the disputes that can be governed by the RERA can be also dealt with under the Consumer Protection Act, and the district forum under the RERA Act is no way inferior to that of the authorities under the RERA Act. It is an option left to the allottee to pursue whichever remedy he likes, but he has to elect. He can't proceed on both the footings because that would tantamount to an abuse of the process of court. Now, the fact that this has to be, that he has to elect, there is another judgment which I just draw your attention to. I will not place it in detail. This is a 3-bench judgment of our current Chief Justice of India. This is reported in 2021. Volume 3, Supreme Court Cases, page 241. This is on unfair trade practice. This is where the housing, if you can draw our attention to paragraph 30. Excuse me. Paragraph 30 is where under this 2019 Act, this jurisdiction of RERA comes in. Yes. In LDA versus NP Gupta, this court discussed the legislative intent of including housing construction within the ambit of service. This is where for the first time Supreme Court brought in the housing industry under the old Consumer Protection Act. A scrutiny of various definitions such as consumer, service, trader, unfair practice indicates that the legislature has attempted to widen the reach of the Act. Each of the definitions are in two parts, one explanatory and the other explanatory. The explanatory or the main part itself uses the expression of wide amplitude, including clearly in its wide sweep when its ambit is widened to such things which other things would have been beyond in its natural import. Manner of construing an inclusive clause and its widening effect has been explained. Words include, this include you find many times been used in the definition, and includes, so that makes it expandatory. Include in very general used in the interpretation clauses order to enlarge the meaning of the words or phrases occurring in the body of the statute. And when it is so used, these words or phrases must be construed as comprehending not only such things as they signify according to their natural import, but also those things which the definition clause declares that they shall include. So meaning thereby, what the Supreme Court is trying to say, that if you look at the definitions clauses in the Consumer Protection Act, you will find that they have explanatory clauses, words which can be construed to explain, and words which can conclude, which can be construed to expand. If I say this consumer means, that means I am explaining what a consumer means. But if I at the end I say and includes, that means the legislature is trying to give a wider. So it is for the court to see whether the definition allows the court to expand. If the court can expand the definition, having taken recourse to these words used by the legislation, therefore the intention of the legislation would come out from these. Now, this is where how the housing services were brought into within the ambit of the Consumer Protection Act. And similarly, you will find when I go to the next topic, which is medical negligence, you will also find over there that by using this power of explaining, it has brought in the medical services or the medical fraternity. Now, so far as this judgment is concerned, this has followed the previous judgment. Only thing that this is a bench of little higher strength. And paragraph 36 onwards is the discussion between RERA and Consumer Protection Act. I am not troubling, I have just read it. If I can just place only one paragraph of it, which is what I was trying to get at, paragraph 37.5. Yes, after discussing the object and scope of both the acts and the area of their operation, this is what the Supreme Court has said. An allottee may elect or opt for one out of the remedies provided by law for redressal of its injury or grievance. An election of remedy arises when two concurrent remedies are available and the aggrieved party chooses to exercise one, in which event he loses the right to simultaneously exercise the other for the same cause of action. This is what I was trying to say. So just because it is concurrent doesn't mean that he gets the right to do both. He has to elect on the same cause of action. If he has chosen the Consumer Protection Act, then whatever remedies are available to him under the Consumer Protection Act can be given to him. But thereafter, after election, he cannot go back to the RERA Act and say that now give me the protection. For that, the previous judgment says he has to seek leave of the forum, withdraw, and thereafter initiate. So this is basically all that I had to show. These are the two judgments which are now probably of the latest judgments of the Supreme Court on a comparison of RERA and consumer protection. Now our next topic is medical negligence. So far as medical negligence is concerned, you will find that in the definition under the 1986 Act, medical negligence was not within the definition of service. It was not there. It is only by judgment law the Supreme Court had brought in the services, so that the services on account of medical score can be availed of a consumer and complaints can be lodged before the district forum. Now this, I will show how this judgment has now been roped in. If you could share, sir, if you could share this judgment. This is pre-amendment, this is 1995, volume 6, Supreme Court cases with 651. Yes. This was under the old Act. Now, after having discussed the scope of the old Consumer Protection Act, this is how services were roped in under the previous law. If you come to straight to paragraph 55, I am trying to cut it short. This is how we roped in the medical fraternity. On the basis of the above discussions include how to interpret services and what is the scope of the Act. On the basis of the above discussions, we arrive at the following conclusions. Services rendered to a patient by a medical practitioner, except when the doctor renders services free of charge for every patient or under a contract of personal service, by way of consultation, diagnosis, treatment, both medicinal and surgical, would fall within the ambit of service as defined under 210 of the Act. 210 of the old Act defines services. Define services, it's not there, I'll just place it. No. Oh, you can go to that Act. Go to that Act, please. Services would be O. Services. Services means service of any description. Kindly see, these are expandatory, any description. It doesn't, which is made available to a potential user and includes the provision of facilities in connection with banking, finance, insurance, transport, processing, supply of electrical or other energy, board or lodging or both, housing construction, entertainment, amusement, or the purveying of news or other information, but does not include rendering of any service free of charge or under a contract of personal service. So, if you look at this definition, you will find that the medical fraternity is not there. But it means any description of any service of any description. That is why the Supreme Court, taking refuge to that two words in the definition, has decided in this manner. Now if you could come back to the old. The fact that a medical practitioner belongs to a medical profession and is subject to disciplinary control of the Medical Council of India and of state medical councils constituted under the provisions of the Indian Medical Council Act would not exclude the services rendered by them from the ambit of the Act. A contract of personal service within quote has been given here has to be distinguished from a contract of personal services. In the absence of relationship of master and servant between the patient and the medical practitioner, the services rendered by a medical practitioner to the patient cannot be regarded as service rendered under a contract of personal service. Such service is service rendered under a contract of personal services and is not covered by the exclusionary clause of the definition of service is 210 of the Act. So it is coming from the other way around. So if it is not exclusively excluded, then the presumption is it is included in any definition. It's coming the other way around. The expression contract of personal service in 210 of the Act cannot be confined to contracts for employment of domestic servants only, and the said expression would include the employment of a medical officer for the purpose of rendering medical service to the employer. The services rendered by a medical officer to his employer under the contract of employment would be outside the purview of service as defined in 210 of the Act. Service rendered free of charge by a medical practitioner attached to a hospital, nursing home or a medical officer employed in a hospital, nursing home where such services are rendered free of charge to everybody would not be service as defined under 210 of the Act. The payment of a token amount for registration purpose only at the hospital, nursing home would not alter the position. Services rendered at a non-government hospital, nursing home where no charge whatsoever is made from any person availing of the service, and all patients, rich and poor, are given free service, is outside the purview of the expression service as defined in section 210 of the Act. The payment of a token amount for registration purpose only as the hospital, nursing home would not alter the position. Services rendered at non-government hospital, nursing homes where charges are required to be paid by persons availing of such services fall within the expression service as defined under 210 of the Act. Services rendered at a non-government hospital, nursing home where charges are required to be paid by persons who are in a position to pay and persons who cannot afford to pay are rendered services free of charge would fall within the ambit of service as defined under 210 of the Act, irrespective of the fact that the service is rendered free of charge to the persons who are not in a position to pay for such services. Free service would also be service and the recipient of consumer under the Act. So here, even if there is no passing of consideration, you cannot say that you are not accountable. So accountability is very much there. Then services rendered at a government hospital, health center, dispensary where no charge whatsoever is made from any person availing of the services and all patients, rich and poor, are given free service is outside the purview of the expression service as defined under 210 of that. The paying of token amount for registration is only at home would not alter the position. Services rendered at a government hospital, health center where services are rendered on payment of charges and also rendered free of charge for other persons availing such services would fall within the definition of service in 210, irrespective of the fact whether the service is rendered free of charge to the person who do not pay for such services. Free service would also service and recipient a consumer under the Act. Services rendered by a medical practitioner or a hospital, nursing home cannot be regarded as service rendered free of charge if the person availing of the services has taken an insurance policy for medical care whereunder the charges for consultation, diagnosis and medical treatment are borne by the insurance company, and such service would fall within the ambit of service under 2.1. So this is where the first time, and in this manner the services were, the medical fraternity was roped in. Now this had caused a lot of hue and cry, because doctors thereafter started to argue that we are not going to give any free service. If we are responsible for everything and anything, then we would be only governed by the hospitals who would take, we can take recourse to. So that is where the hospitals and the corporate entities came into the forefront. Now, a very interesting thing which I would like to show is when this 2019 Act was debated in the Parliament, just can you take out that debate? Legislation debate, the heading is legislation. Lok Sabha, synopsis of debate. Yes. Now this debate, the legislators were debating on the 2019 Act, and after the speeches of all the speakers were there, the minister in charge had made this statement in the Parliament, which is, if you come to Sri Ram Vilas Paswan replying said, it would be page 19. Scroll down. The reason why I am showing you this, yes. How come it's not? Kindly see, this is what the minister had to say. I hope this is in answer to all the debates, this is his final speech. I hope that this Commission Protection Bill, this is the 2019 Consumer Act Bill which we are discussing. I hope this is the Consumer Protection Bill will prove to historical bill. Several honorable members have expressed their views on this bill and the government has seriously pondered them. Through this bill, our main objective is to streamline the system of consumer protection. With regard to non-inclusion of healthcare in this bill, I would like to say that under the prevailing scenario, a medical practitioner prescribes medicine for any disease very easily. Whereas, if healthcare is incorporated in this bill, he will prescribe medicines only after advising the patients to go for a comprehensive health checkup. So this is disowning of liability. It will cause extreme difficulties to the patients as it will consume time and money. Over the time level, District Consumer Forum, State Level Commission and National Consumer, could you scroll up please, for national establish the purpose of have gradually taken the shape of courts due to which its main purpose has been defeated. One of the reasons for delay in the courts as well. As per the provisions of this bill, services of advocates are not necessarily required. Now any person can represent his own case. Similarly, if a person fixes any complaint, then the rest of the... What I was trying to draw your attention to is that portion of the statement of the minister, concerned minister, that medical services was kept outside the purview of the new act. But that is so far as the executive is concerned. Now, on the basis of this statement, a proceedings was initiated before the Bombay High Court by the medical practitioners, saying that the minister himself has said that medical practitioners are outside the scope of the order. So therefore, no complaint lies against the consumer protection. Now, sir, if you could share the judgment of Chief Justice Dipankar Dutt in Bombay High Court. It's 2021 SCC Online Bombay 3696. You can go as to SCC online also, that the paragraphs will match. You have SCC online, the second one. No, I need the judgment. Is there in my compilation? Yes. So you can take it out from the internet. You just took it out from the internet. Yes, this is the one. Delhi CMI versus. No. It is Medicos Legal Action Group versus Union of India. Yes. Anyway, let us see the paragraph. Paragraph 3. No, it's not matching. Yes, the ground on which such release. Yes. You see, this is all that I could lay my hands on. This is the current law. After the 2019 Act came into force, this group of medical legal action group, the group of lawyers who had challenged and taken up these proceedings by way of a public interest litigation, to get an observation from the court that the medical fraternity is beyond the scope of the Consumer Protection Act by virtue of that statement made by the minister. Paragraph 3, the ground on which such reliefs as noted above have been claimed is that the parliamentary debates on the Consumer Protection Bill 2018, hereinafter referred to as the Bill for short, preceding the 2019 Act, led to the exclusion of healthcare from the definition of the term service as defined in the bill. This was the issue before the court. It has been stated in paragraph 5.11 of the writ petition that the Honourable Minister for Consumer Affairs, Food and Public Distribution has stated on the floor of the Parliament that healthcare has been deliberately kept out of the 2019 Act for the reasons cited therefore. The reasons is what I just placed before this. This clearly indicates that the parliamentary intent of not including healthcare within the definition of service in the 2019 Act reveals that the petition in trust, and therefore. Now, the observations of the court are from paragraph 6 onwards. Paragraph 6 describes section 210 and then discusses the 1995 judgment of Indian Medical Council which I just placed. And after quoting that paragraph, paragraph 8 is what the decision of the court is. Paragraph 8. No. Paragraph, we see no reason to hold. Yes, paragraph 7. Now, after considering the 95 judgment which is under the 86 Act defining services or interpreting the service, the court under the new Act holds, we see no reason to hold that merely because the enactment of 2019 Act upon repeal of the 1986 Act as well as the parliamentary debates referred to by the petitioning trust, the efficacy of the law laid down in the decision in Indian Medical Association as a binding precedent would stand eroded. The definition of service in both the enactments, repealed and new, are more or less similar, and what has been said of service as defined in 210 of the 86 Act would apply ex priori vigo to the definition of the term service in section 2 subsection 42 of the 2019 Act. Therefore, we have little reason to hold that the services rendered by doctors in lieu of fees charges therefore are beyond the purview of the Act of 2019. So this is the present jurisdiction has now been restored back. It was never taken away to start with, but it has been clarified that there was never the intention of the legislatures to take away the jurisdiction of the consumer protection, the district forums and the other forums from examining a case of medical negligence. So this is so far as medical negligence is concerned. So far as consumer disputes is concerned, is there any specific query, because there is a lot of literature behind it, then I can curtail because it says insurance sector. I really don't know what does it mean, but it doesn't have any specifics. So what I could understand is probably the institute wants to know as to what is the current position of law vis-a-vis the 2019 amendment, because it doesn't say anything. It says insurance sector. Be that as it may, what I have been able to lay my hands on after this research is the dispute regarding the insurance sector and the jurisdiction of the consumer forum fell for consideration very recently before the Supreme Court. This is reported in 2024 SCC Online. Five to five, yes. Now this discusses the law as to the change in insurance law prior to its amendment and after its amendment, as well as the obligation of how to interpret insurance contracts and what is the duty of a court. If this is a very long judgment which takes into account everything. Now I leave it to you. All this says, if I may just try and summarize it in my own words, all this says is that a contract of insurance has to be interpreted under the principles of Ubi Ref. It says, if you can just scroll down to paragraph 11 onwards. Because predominantly all insurance contracts or all disputes regarding the insurance sector circulates around only one issue, is whether I am liable to a claim or not. And what we find is that insurance sectors, they seek to avail the first opportunity to decline a claim. They decline a claim, and in almost all cases, the decline, the refusal to perform their obligation is on the ground that there has been a change of status or a suppression of a fact at the time of obtaining the insurance. And therefore, now that it has revealed that there has been a change of status, we are not liable to honor our obligations, and they try and seek refuge to courts to say that you first go and have your right established. That's the reason why insurance sector was brought within the domain of consumer forum. It was there from 1986 and it's even there. Now, what the courts have evolved over the years is, if I may just show to you, paragraph 12. In order to answer, having considered paragraph 11 onwards, having heard the learned counsel, so that the point that arises for consideration before this court in the present civil appeal is whether the respondent hearing was correct in repudiating the claim of the appellant on the ground of suppression of material information pertaining to the existing policies with other insurers. In order to answer this question, it would be useful to recapitulate the relevant provisions of the law of insurance and evidence vis-a-vis the burden of proof and the method of discharging that burden of proof to prove an alleged fact, which is suppression. Then it discusses the law. I am not holding you back on the question of law. Then it discusses the theory of full disclosure theory, which is also not very relevant over here. Then the important thing, which may be of some importance to us, is paragraph 30. These are some of the guidelines. The basic rules to be observed in making a proposal for insurance may be summarized as under. So when we are deciding on the question of suppression, we need to go back to the point where the contract was entered into. And at that point of time, the guidelines which have been laid down are this: a fair and reasonable construction must be put upon the language of the question which is asked and the answers given with similarly construed. This involves close attention of the language used. Then carelessness is no excuse unless the error is so obvious that no one could be regarded as misled. If the proposer puts no when it means yes, it will avail him to say that a slip of the pen. The answer is plainly the reverse of the truth. The answer which is literally accurate, so as to the extent will suffice it. Where the space of the answer is left blank, this is regarding filling up that form of insurance. So these are the guidelines which the court had considered following the Halsbury laws of England. And I can tell you the sum and substance of this is that an insurer who has promised to give his services in case of certain contingencies would be held responsible for holding on to pay the same till such time he can show or discharge before the district forum that his services were availed by practicing fraud or misleading statements or suppression have taken place, which had he known, he may not have extended the policy of insurance to the insurer. So that is the test which the Supreme Court has laid down, and it has also said that if there are certain discrepancies and in the declarations, you have a reasonable time limit within which you can come and say that. But if you have allowed it to run the way it is and you have gone on taking premium year after year, when it comes to your turn to pay up or comply your obligations, if you take the defense of suppression, the test has to be of the highest order. And that is what is the sum and substance of this judgment, which probably also is the law. Now, so far as e-commerce is concerned, the next topic, I am not delving on insurance because it is not very specific. So far as e-commerce is concerned, all of you are aware that e-commerce has been brought into the Act by implementation of the Consumer Protection E-commerce Rules of 2020. These rules have been framed in exercise of powers conferred under subclause ZG of subsection 1 of section 101 of the Consumer Protection Act 2019. If you can take out the rules from the internet. It is the Consumer Protection E-commerce Rules. It was gazetted on 23rd of July 2020 and amended on 17th of May 2021. Yes. Open it. So the English will name. No, that's another. Yes, thank you. As you can see, these rules have been brought into force by powers given to under the Act itself, and whatever changes that has been brought into the Consumer Protection Act by virtue of event of e-commerce is governed by these rules. What these rules have introduced is, if you can just go to scope and applicability, say that as provided by the central government, these rules apply to all goods and services brought or sold over the digital or electronic network, including digital products. All models of e-commerce, including marketplace and inventory of e-models of e-commerce. All e-commerce retail, including multi-channel single brand retailers in single or multiple formats. And all forms of unfair trade practice across all models of e-commerce. These are the four things which governs the right of the Commission as far as e-trade is concerned. Now what it has introduced is Rule 4. This is a concept which has come, and this is where they have fixed the responsibility. Where an e-commerce entity is a company incorporated under the Companies Act 56 or under the Companies Act of 2013, or a foreign company covered under 42 of Section 2 of the Companies Act, or an office, branch or agency outside India owned or controlled by a person resident in India, as provided in subclause 4 of clause 2 of Foreign Exchange Management Act. It shall appoint, this is important, it shall appoint a nodal officer or an alternate senior designated functionary who is a resident in India to ensure compliance with the provisions of the Act or the rules made hereunder. So foreigners carrying on international trade gets roped in. Every e-commerce entity shall provide the following information in a clear and accessible manner on its platform, displayed prominently to its users, namely the legal name of the e-commerce entity, the principal geographic address of its headquarters, name and details of its website, contact details like email address, fax, landline and other mobile number of customer care, as well as of grievance officer. Then no e-commerce entity shall adopt any unfair practice, whether in course of business or its platform. This is what I was trying to say. Every e-commerce entity shall establish an adequate grievance redressal mechanism, having regard to the number of grievances ordinarily received by such entity from India, and shall appoint a grievance officer for consumer grievance redressal, and shall display the name, contact detail and designation such officer on its platform. Every e-commerce entity shall ensure that the grievance officer referred to in Sub-Rule 4 acknowledges the receipt of any consumer complaint within 48 hours and redress the complaint within 1 month from the date of receipt of the complaint. So, when I was reading this rule, there is no literature on this as of now. What I was thinking is, if I buy a product, there is an option for returning the product also on online. Now, when I am to return the product, there are certain boxes to be ticked as to why I am returning the product. But there is also a space provided that if it doesn't fit into any of the boxes, you can give the reason for it. Now, suppose I say as a consumer that I don't like the product, then would it be a good and sufficient reason for the consumer to take it back, for the product to take it back, supplier to take it back? To me, as I have understood, yes, it would be a reason. Because of the very simple logic that if I have bought a product online and the representation of the product online is not the physical representation of the same, then I am within my limits to say that had I seen it physically, I may not have bought it. So therefore, this provides for a redressal officer. So this information actually goes to the redressal officer, who will within a month will either refund my money or take back the products, but no questions asked, they don't do it. Where an e-commerce entity offers imported goods or services for sale, it shall mention the name and detail of the importer from whom it has been purchased the goods and services, or whom the seller on its platform. Then there are other obligations. Every e-commerce entity shall endeavor on a best effort basis to become a partner in the code. That's not very necessary. No e-commerce entity shall impose cancellation charges on consumer cancelling after confirming purchase, unless similar charges are also borne by the e-commerce entity if they cancel the purchase order unilaterally for any reason. Every e-commerce entity shall only record the consent of a consumer for the purchase of the goods or services offered on its platform, where the consent is expressed through an explicit affirmative action. That is why we have the option, we break it up. Nowadays we find they break it up. You choose it, then after you put it into a cart, from the cart you proceed to buying option, and till the last time when you say that yes, I want to buy it, there is always an option open given to you to withdraw. So these options have come, or these features have come just because of these rules. So these are the obligations of persons who are carrying on business online, and these are the requirements that is required to be fulfilled. Then it goes on to say the duties of sellers and buyers in marketplaces, and clause 8 would be relevant. I don't want to take you, I'm sure all of you are aware of all this. What is important is Rule 8, provisions of the Consumer Protection Act shall apply for any violation of any of the provisions of these rules. So the rules not only to have a statutory force, the enforcement of these rules are also brought within the ambit of the statute. So this is so far as e-commerce is concerned. Now comes the question which we will have to discuss, is determination of compensation. Now, compensation is akin to damages. I remember when I was giving this, when we were discussing the question of defamation, there also this question of damages had come up. And the question that troubles everybody, at least the person who is adjudicating, that it's easier for me to find out who is responsible. But how do I compensate and what is the value of compensation? The Consumer Protection Act does not provide for it. So we will have to take recourse to the Contract Act. Now, Supreme Court in very many judgments have said that compensation is not a profit-making effort. Compensation means that I am restituting you to the position possible by the mechanism of law that can be done. It follows from the principles of restitution. So it's like if I have suffered anything, if I have suffered any loss which is monetary, then the court's endeavor should be to put me back to the position which I would have been had I not gone into the contract. Now, that principle is enshrined in the Contract Act, which we all know is Section 73. 73, if you could please share 73 of the Contract Act. Now there are three options. A contract can be void, a contract can be voidable. In both these two cases, the Contract Act says that if it is void, nobody gets any benefit out of it. Everybody has to be put back into the position had the contract not been performed. That's one restitution. If it is voidable, in that option, the person who is exercising his right and saying that the contract is voidable, he should get back the money or whatever he has invested to the extent possible. So these are when the contracts are void and voidable. But what happens in case of a breach? That is Section 73. We are all aware of it, and this is the principle that still holds good so far as allowing compensation under the Consumer Protection Act is concerned. I need not read 73 to you. So what we will have to find out faced with such a situation is to what loss did occur naturally, not exceptionally or exponentially, what loss naturally arose in usual course of things for the breach that the consumer is complaining of. If we put it by way of examples, if I have brought a defective good which is covered by a warranty, then it all depends on the nature of the warranty. It can be a manufacturer's warranty, it can be a dealer's warranty, it can be a replacement warranty, it can be a warranty limited only to the extent of services. So these are the various types of warranty that a product comes with. Now a warranty and a guarantee is not breach, because that is a condition which comes with the product. Breach will occur after having expired the provisions of period where the guarantee and warranty is over, and thereafter it appears that the product is absolutely defective. Then what happens? Mind you, when the court is deciding this, the court, if it's a defective product to start with, then the question will arise that you have to give it back and refund. But what happens if I buy a product and I use it for 7 years? Like I say, nowadays the AC compressor has a warranty, life warranty of 10 years. But I've used the AC for 7 years and thereafter for whatever natural reason, it broke down and the compressor needs to be replaced. Then would it be just and proper to ask the manufacturer to replace the AC? No. Would it be just and proper for the court to say that since the guarantee is there, you do it free of cost? No. He will do it, he will provide the products, but he will take the service charges. And if the consumer refuses to take the good thereafter, he will not be mitigating the losses which he has suffered. So therefore he can at best get back what is called a nominal damage, if at all he has suffered any. Suppose if the company wishes not to pay, he can go to mediation under the new act and he can say very well, I am not able to give you that services anymore for whatever reasons. You take this amount of, and if they accept it, that is one of the purposes not to come to court. But if you are to compute damages, you will have to balance the equities of both the sides. If it is unfair trade practice, which goes to the root of the matter, like I would not have purchased it at all, or I would have not entered into your contract at all, or I would have not accepted your offer at all to start with, then comes the question of restitution in its entirety. But having been deceived, if I have acquiesced in that deception, I have used that product. Suppose I buy a car. The defects in the car will only emerge after 1 or 2 years. not prior to that. It's a good running car, I don't know. After 2-3 years, it starts to throw up for whatever reason the defect is. If the defect is incurable and if it can be shown that it was a defect at the manufacturer's point, then it is the obligation of the manufacturer to restore it to the condition as on the date when he sold the vehicle. If he is not in a position to do it, then he will have to pay the compensation for the cost that would be involved for getting, because I never intended to buy a defective car to start with. The fact that the defect has emerged after so many years, or after 2 or 3, or they are within a reasonable time, and that defect is for no fault of mine, then the manufacturer will have to either pay me the cost for getting repaired, or he will have to replace or redo the entire thing at his own responsibility. Because that is restitution. But in the event of doing it, if I have used the car for 2 years and I have handled it in such a manner that has actually gone on to what should I say, add to the damage that was already there, then I am also responsible for what we call contributory negligence. I have contributed to that negligence also. So that will bring down the quantum. Now the question is by how much? That's the question. Section 73 does not lay down any guidelines as to how compensation. So far as this clause has fallen for consideration in arbitrations and other civil court, Supreme Court has gone to say that it is not possible for a court to fix the exact quantum. So it can be reasonable. Now what is reasonable is the yardstick that you put me back into the position that I would have been had I not been, had the breach not occurred. And if that is on one side, the other yardstick is that even if there is a breach, have you acquiesced in the breach? If you have acquiesced in the breach, then your right to claim full compensation gets diminished. So that's the way things are balanced. If it's a contract of insurance and the insurer refuses to pay, and ultimately the forum comes to the conclusion that the insurance company is liable to pay, then apart from paying that money, the two other portions that will come into the picture is interest for delayed payment. Because had you paid the money on the date I made the claim, that was the day I would be entitled to get that money. So it's reasonable interest. From the date I made the claim till the date the court held that I am liable to pay. I am liable to receive payment. I am entitled to receive payment. The other damage which may be factored into this is mental agony. That I had to run pillar to post, cause this. But this is something which you cannot assess. So it has to be either nominal or something which is left to the discretion of the court. And that's the reason once a discretion is exercised by a court, the higher authorities or the appellate authority do not interfere with such discretion. Because that's the best judgment also. So far as medical negligence is concerned, in this field, if there has been a loss of life, then we can apply the principles which we apply under the motor accident scheme. If it is loss of limb, those principles can be applied. Coupled with the fact, but having said that, I need to add that so far as medical negligence is the power of the district commission to award compensation is not curtailed by the principles. It's only the guiding factor. The judge may feel that, well, this man is entitled to more compensation for whatever reason being the facts of the case. So just because I say that we can take help from the principles does not mean that the embargoes will apply. We have the courts have full discretion to it. So far as housing is concerned, whatever the Supreme Court has done is this. For delayed delivery of flats, they have allowed they have asked the promoter to pay compensation by way of interest. Now, compensation has been defined under the RERA Act. If and what would be the compensation, what would be the interest, it has all been explicitly stated under the RERA Act. What I think, it's my view, is if both the remedies are concurrent, then the substantive portion of the law in RERA, which says that I am entitled to interest at this rate, those are the substantive law. That substantive law would equally apply to the district forum who would be judging a case which falls both under the purview of RERA as well as the consumer. So while deciding a case under the Consumer Protection Act relating to housing industry, we can very well take recourse to the statutory or substantive provisions of the RERA Act and decide compensation in terms of that act, because the Supreme Court has said that both remedies are available to me. So the substantive portion of that law, like right now I am facing currently I am arguing a matter before the High Court. If you are interested, I can share. Is that my clients have entered into a contract with Merlin, I don't want to take the name, with a promoter for the purpose of purchasing a flat. Both husband and wife went and signed a contract saying that we will purchase the house for 2 crores, a flat. They paid partial advances, and unfortunately my client's husband passed away in the interim. So she was no more in a position to buy the flat. Financially, nor did she want to buy the flat because both of them wanted to go and stay there. So out of that 1 crore 30-40 lakhs, whatever the flat consideration was, my clients had already paid 60 to 70 lakhs. And at that juncture, due to change of circumstances, they wrote to the promoter that we are no more interested in buying the flat, give back my money. The promoter in turn wrote back saying that yes, you have paid me 60 lakhs, but we will give you back only 20 lakhs. Why? Because I have already incurred expenses, number one. There is a clause for damages in case of cancellation, and I have also paid GST on that, which is irreversible. So due to these 3 circumstances, I am forfeiting 40 lakhs of rupees, and I am only ready to give you back 20 lakhs of rupees. Now when this dispute arose, although the RERA Act was there, the forum was not constituted in Calcutta. So we had the law, we did not have the bench because it was not constituted. So at that juncture, we had to file a suit, because unless there is a forum, I can't go and approach that forum. So the only remedy is under section 9 of the CIR. I have to file a suit. Now they have come up and are trying to argue that there is an arbitration clause hidden somewhere in that general terms and conditions, and they can go to arbitration. And I am now trying to contend that it can go to either RERA, but since as on the date I filed the suit there was no forum, so the only option left to me is the present civil court, and I cannot be faulted because as on the date of the cause of action there was no forum. Now in this scenario, 2 or 3 things are available to me. I can well go and argue before the court that this stand taken by the respondent that I am entitled to withhold this money is against the substantive law of RERA itself. It doesn't allow them. If I cancel an allotment, he is supposed to give me the money with interest. So you cannot rope in a clause which is contrary to the law. Therefore, these clauses in the contract are all void because they run contrary to the law of the land, which is the contract, and are unenforceable. And the matter is going on and it's being argued, but I believe the court is with me to the extent that these clauses, which are all one-sided, they cannot be enforced because of the substantive law, although I am not before the tribunal. So here also what I am trying to say by that, since they are concurrent remedies, the district judge or the district commissioner who is deciding a case on housing can very well, while deciding compensation, apply the law, substantive law that is available to an allottee under that act. And that act is also in favor of the allottees itself. So these are the ways and methods by which we can actually decide the compensation. The basic idea is to put back the person to the place that he, to the extent possible. It's not, it is possible to the fullest extent, but to the extent possible. I think that brings us to an experience and challenges is somewhat minor. It's for all you to say what are the experiences and challenges that you face in court. I am, as a lawyer, I only look at one side of the story. And you as judges look at both sides. So, that's not within my domain. So, my lords and my ladies, I think this is all that we had to discuss today. And if you have any queries, I'll try and assist you to the best of my ability.